It is always easier to talk in front of a crowd with emotion. Yeah. That's going on. Okay, so I am with Bogartz beforehand. I am in charge of their business law group, which, although some of the services have been provided in the past, it is now a whole new group, and I've been there almost a year now. In the past, I've done litigation, I've done business, I've been in-house for many years, so I've seen a lot of everything, and kind of bringing it all together here. The reason I am here to talk to you today is I get constant calls from agents and clients of agents, clients that have come in to close a house, and at closing, they say, oh, I'm buying this for rental property. Do you all do leases? Do you have someone who does wills? Do you have someone who knows how to form an LLC? What name should I put this in eventually? All that lands with me. So we're going to do a little quick crash course on a lot of it. And then I'm happy to take questions during. Just raise your hand and jump in, and we'll cover this quickly. Kind of covered this. The main thing my group does, we do a lot of company formations. We do a lot of discussions about that. You know, what kind of company to form? Is it necessary? Wills, trust, and estate planning seems to be a natural branch off of, you know, now I'm buying my second rental property. Oh, my assets are growing. Do I have young kids at home? Do I need to start thinking about this? And then we get from step one, now we're in wills and estates. Hopefully a very long time in the future that we're talking probate. But we do all of that, and then there's some other things I'll touch on. Basically anything that's contract law, writing, reviewing leases, all kinds of other. If it lands in business, call us. We can potentially help you, and if not, we'll get you to someone who can. Company formation. So why? Why would people ask about this? Number one, you're talking to the attorney side, so you're going to get the limited liability asset protection. If you form an LLC, and a lot of you probably already know this, if someone sues you, they are limited to the collection of your assets in that company. So it's separate from your personal assets. When you form a company, even if you are the sole owner, the sole member, that company is a different entity than you. So that is why that limited liability exists. That's why there's an LLC called a limited liability company. We'll talk a little bit more about that in a minute. For tax purposes. So when you get into this area, if you call and say, I want to form a company and here's what I'm thinking, you will always hear from a lawyer. You should always hear from a lawyer. Run this by your accountant, because we don't give tax advice. Everyone's financial situation is different. Here's from the legal side, here are some options. Run this by your accountant to figure out what's best for you. They're going to throw some things in the mix. And then ultimately, you can come back and say, all right, we've talked to you, talked to my accountant. This is how we're going to structure this. And then privacy. So we're going to get into that a little bit more, but it's a question I get a lot. Like, I don't want my name on the deed. How can I keep it quiet? Someone called the other day. I want to know where she lives because she said, I get 20 calls a day. People trying to buy my house. Really? I don't know where it is. But so she was very interested in privacy. So we'll talk about that in a minute. There are options. LLCs are the most common thing that I see. They're inexpensive. They are easy to form, and there's not the corporate formalities that you have with a corporation. A C Corp you have to have bylaws, you have annual meetings, you've got just a lot more formalities. You're supposed to have consent minutes for a lot of things, and it's double taxation. So that's a big one. With an LLC, again, we're kind of in the accountant world, but it's a pass-through tax. So it is not subject to the double taxation. So it provides that asset liability protection without the taxing. And the formalities are much less. So you don't, the equivalent of bylaws for an LLC is an operating agreement. You don't have to have one. I do recommend it if there's more than one member. Conversation if it's spouses, maybe not, but if you're going in with a business partner, I do recommend it because it is well worth the money at the front end to decide what's going to happen when someone wants to leave. What happens if there's an ugly breakup, a nice breakup? How do we get out of this? The operating agreement spells all that out ahead of time so that you're basically just following a roadmap of what to do to get out. There is also an S corporation, which is an election if you're a C corporation to get that pass-through tax. I do not see many of these, but this comes into your conversation with the accountant based on your own personal finances and how you do your taxes as to would that make more sense for you than an LLC. How to form it, I think, I don't know if people think it's a big deal to form a company. It is not. It is quick. It is easy. Number one, choose your name, which can often be the hardest part because I've had people weeks. I'm still trying to work on that. Much bigger deal if you're branding under that name or the name's going to be out there. If you're forming it to hold some property you bought, you probably don't care. The name has to be available. So you can go on the Georgia Secretary of State website, put in business search, and put in the names you're thinking about. If it pops up, it's not free. If the name is very important to you, once you find one that you think is free, we can reserve it for you for 30 days so that you get the name, reserve it. I think it's like $25 or $30. Then you have 30 days to get your articles filed and get it formed. You don't necessarily have to do that if you don't care what the name is so much. We file the articles of organization for an LLC, same thing as an articles of incorporation for a company. They're filed with the Georgia Secretary of State, $100 filing fee. You can expedite it, but usually 5 to 7 days, even if you don't expedite it, it's formed, you get the certified copy. If you need it in a day or two, well, I'd say 2 days, you can expedite it. So it's something that can happen that quickly. Already kind of talked about operating agreements, bylaws, more than one, ask about them and get some more detail about what they have. The principal office registered agent, this goes to privacy. So when you file with the Secretary of State, you have to list a principal place of business and you have to have a registered agent. The registered agent absolutely has to be in Georgia. The purpose for a registered agent is they receive service of process. So if you're going to be sued in a lawsuit, the private process server, the sheriff will show up with your papers. The reason it's important and important to keep it updated is if you are served with those papers properly, which they'll go on the Secretary of State website, they will find out your registered agent, that's where they go, it's signed for there. You then have a limited period of time to respond to that complaint. If you don't respond, it goes into default judgment. So if you form a company, there's annual filings, make sure that's kept up to date. Hopefully you will never need it. And it's something you're like, yeah, well, I'm never going to need that. And hopefully you won't. But you want to make sure that you do get that service. It isn't just thrown on a desk. Rental properties, don't use your rental property address as a registered agent because that's where your papers go. So they are supposed to have the person sign it, but it can lead you to extra fees and litigation and whatever, trying to sort all that out. So if you want privacy, there are companies that will serve as a registered agent for a monthly fee. So if you don't want to put it in your name on there or have your address, you can pay, Google it, Georgia Registered Agent Service, and several will pop up. The nationally known ones like CT Corporation cost more, but there's also some more local ones that you can get that for a reasonable fee if privacy is important. We went over filing fees. The EIN number is the equivalent to Social Security number for an individual, but it's for a company. The reason this is important is we're back to limited liability. So when you have your company, it needs its own number, it needs its own bank account. Usually you need your number to open your bank account. This is very important because there is something that in the legal world we call piercing the corporate veil. What that means is I'm going to sue you and I'm going to sue the LLC, but I'm also going to name the owners of the LLC and everyone else who I can think of. The owners will have that asset protection and can get out of the lawsuit, usually, unless they pierce the corporate veil. And that means I've been intermingling my funds. So I get my rentals from the properties. Sometimes I deposit it with my LLC bank account. Sometimes I deposit it in my own bank account. Sometimes I use my personal credit card to go buy stuff from my company. You intermingle, you lose your asset protection. So it's just, it is a whole separate person. So everything has to stay separate. There is the new Corporate Transparency Act. A lot of you might have heard of this out there. What it basically has started in January of 2024. There's some legal things going on around about it. We'll see. There's some suits that have been filed, but it is a filing that's required. You go on a website and you have to list your beneficial owners and some other information about the owners. It is to reduce fraud in small companies, but it's federal. It's, so when you form a company, we send you the link that you need to go to register. And then both LLCs and corporations have an annual registration. That's it. Then you can be up and running within a week. So if it's not something you've done and you're interested, it is pretty easy. Back to the privacy again. I get this question a lot. Well, I was thinking of forming an LLC in Wyoming or South Dakota, because Wyoming and South Dakota, and there might be more, put out a lot of information about you get privacy here, you get privacy here. I don't practice law in Wyoming or South Dakota, so I don't know all of their laws. I do know in Georgia, people can find your information no matter what. I find it hard to believe that they can't find your information in Wyoming or South Dakota, but they might make it a little harder. But even if it's hard, if you're named in a lawsuit, as soon as discovery starts, you get your interrogatories, and it's who are the owners of this company? What is their information? You still have to release information ultimately. Now, if you're the person who said she gets 20 calls a day and that's what you're trying to avoid, maybe it makes sense to have an outside state as your LLC organizer, but talk to an accountant because you get double taxation. So just it's never simple, right? There's always more to consider than just, oh yeah, let's just do this quickly. And today I'm just kind of throwing out the high points so that you know, like, the phone calls you should make. So this leads us into wills, trusts, and estate planning, because I get the question a lot of, should I do an LLC or should I do a trust? What's the difference? And I'll say a personal conversation. I see more people ultimately putting in an LLC than a trust, but they're both options. The main estate planning documents that we do all the time are will/trust, because usually we'll have people that want, you can have a simple will, which says, I'm going to give my property to, all my assets to X. Usually there's a trust within that will that says, I'm going to give everything to my spouse. And then after that, it's going in trust to my children. We can stagger, do they get it at 25, 30, 35? Do they get it right away? How old are the kids? Who's the guardians? Who's the executors? All of that we cover. You can do a will online. Those wills are usually pretty simple. Ours are much longer, but the reason ours are longer is we contemplate changes in tax laws so that you don't have to go, I had that will we signed 3 years ago, but now there's been a drastic change in the tax law that I'm hearing, and we can't pass millions of dollars tax-free. So how do I change my will? Ours are kind of set up to contemplate all that with added language, and we contemplate as much as we can in the future. They're always, if you have current ones, but you were thinking, I need to change the guardian, change the executor, make some changes, that is a very simple thing to do. We can just amend them. Then your financial power of attorney and advance directive. Those are for, you haven't passed, but something's happened and you are unable to pay your bills, or sell your house, worst case scenario, because you need it for medical care. Or my father had Alzheimer's. He was like, here's the financial power of attorney, here you go. I handled everything for him for 2 years. So we recommend this, but keep it safe with your will because it's a lot of power. But when you don't need this until you need it. And then the advanced directive is the medical power of attorney. Most important thing there is to name your agent. If you are out of state and you're in an accident, your family finds out, no one can get information easily. If they have an advanced directive, they can send it over and start being involved in, the medical decisions that need to be made. You can also give your agent suggested information and ask the hard questions. And when we do the will signing, those usually get to those pages and it's a deep breath for the person looking at it like, okay, I really got to think about this. You don't have to. You can leave it blank and at least appoint your agent and let them know, or you can be very specific about what you want. So that's kind of the standard package. The trusts, when you hear, I'm going to put everything in a trust, it protects all my assets. Here are the key words: revocable living trust. Your assets are still subject to creditors because it's still your property. Irrevocable trust. Yes, you can protect it here, but it's not yours anymore. It's the easiest way to think about it. You put your property in an irrevocable trust. If you decide you later need to sell that property, you have to get the beneficiary's approval to sell it. That's why it's not accessible, because it's not yours. It's the easiest way to think about it. Usually we are working in the revocable trust world. If you're down here, you've got assets that you're not going to need in the future. Other services, just a quick list of other things we touch on in this crash course. We do a lot of business asset purchases, deed transfers. So your client wants, I want to do an LLC. They strike the LLC. The house is already in their name. We'll help with the deed transfers over to that trust. Drafting, reviewing leases, residential, commercial, general contract review, just about anything. I do those breakups, lots of settlement agreements where they now talked about how one's going to buy the other out, and we write all that up for them. Easements, the sales at a halt, because title companies just let us know we need to have an easement, blah, blah, blah. We can draft those. And just about anything that falls in the business world, call us, and then we can go from there. We also do have a litigation department, so it's something that's kind of getting into the litigation. We can, get you downstairs, and they can handle it, or if they can't, we try to always be able to get you or your client to an attorney that we can at least give 2 or 3 names so that they know where to start, and at least give them information. If it's a trademark patent question, I'm going to say you need an intellectual property lawyer, and this is what you should look for. So we try to help you help yourself and to help your clients as much as we can. So I think all that's left, my information, but I have some cards as well. Any questions? A quick cash list.
So yeah. Y'all better have one.
Yeah,
no,
yeah.
I like
yeah, but I want to make sure.
I get a lot of questions all the time. So a couple things. So say a brand new agent walks in and another new agent comes in and they want to form a partnership. They've got to decide on their name, form the LLC, do all the things, then open the bank account. The partnership portion, writing that partnership agreement that then the brokerage has to keep on file so we understand what that looks like, what they're agreeing to. Do you all draft those? Do you have templates that you share? Like, what does that look like?
We would typically draft them only because they're specific. Now, if we start seeing, so if you have a lot that are coming to us and they're all kind of using the same thing, then we can work on, we'll give a template, but maybe charge for a consult to make sure the template fits everything.
Yep.
Instead of, the full drafting the whole thing. But usually there's more questions when people come in and start talking. They'll ask for A, but then we ask questions and then they're like, oh, what about this?
Mm-hmm.
Right. So but we can work with people if you're like, we always use this one,
okay,
but we just have this one unique thing. we're not going to charge, it's $500 to draft a document when they have 3 questions. We'll just do like an hourly rate and be as efficient as we can.
Got it. Okay. That's
Yeah.
perfect. Yeah, it comes up a lot. So
Yeah.
everyone asks, who's your call? I'm like, call Kelly and Select.
Yeah.
Yeah, they can help you. Yeah, I write it for you.
Right.
Yeah. Okay.
We're there and usually get when the closing attorneys are like, I'm not sure, it usually finds its way.
Yeah. Perfect.
Yeah. So I have a question about trust. So, a lot of my elderly clients, what I understand, and maybe you can help tell me if this is correct or not. My understanding is if they want to put their property in a trust, does that then help with the cost basis for, if the property is sold later, or their heirs and stuff like that? So can you kind of talk a little bit about that? And well, it's a twofold. So the trust as far as that goes, and then a trust as far as, getting, if they eventually, want aid, like Medicare or Medicaid and stuff like that, does that also shield them and stir like 5 years, but that they have to do that before they can get that? So I guess it's a twofold question.
Yeah, so the cost basis one is easy. Yeah, they get the benefit of the cost basis. The property goes in a trust. So if it's sold 100 years later, they get the basis of when they're selling, as opposed to having paid taxes on what they
On
bought.
the original, yeah.
Yes, so that is a reason to put property in a trust. Now, when you're getting into the Medicaid, nursing home, I can avoid. It's very murky, and it's not. The short answer is you can't just open a trust and put stuff in there and go, I magically avoid.
So you qualify for like the assistance portion of care.
Yeah.
Well, and the reason for my question is, the reason people retire in Florida is you can't in Florida.
Correct. And Florida's a different animal.
It's a whole different thing. So I just was curious.
The other thing we get a lot is I have to avoid probate. So I have to put property in a trust so I can avoid probate. But if you live in Florida, understood. Georgia, probate's very easy. It's short. It can be quick. It's not years in the process. So you it's again one of those. You some benefit, but there's also some downside, and it depends on the individual situation as to why else are you trying to avoid probate. And would it actually work, or does it matter? Are you going to spend more setting things up to avoid probate than you would actually probating it and just being done with it? So all individual discussions that we can have, and we do a first consult. When someone calls, I'll usually spend 30 minutes or more on the phone with them, trying to get what are they really concerned about. And if I don't know the answer off the top of my head, we'll get a short answer to them. And that we don't charge for that consult if they come and use our services. The only time that's different is if they say, I have a trust that I drafted. Will you review this and see, what it is like? We will look at it, and if they use us for documentation, we won't charge for that. But if they don't, then we'll charge a consult fee to review what they already have to say. Now, if it's a 5-minute review and we go, no, you're pretty much all good, just update your executors with a 2-page amendment, which is called a codicil for a will, then we'll, it's all wrapped into flat fees. We do this all flat fee, not, by the 6 minutes.
6 minutes.
So was there a question back here?
Yeah, I've got a question. I formed my S corp back in 1990. And I've got 2 questions. One is that something that needs to be reviewed because of law changes? And 2, is there any benefit to an LLC over an S corp?
So that you're getting it. So from liability perspective, no, but ask your accountant based on your own personal tax situation. If you've kept your S corp up and done the annual filings and it hasn't been administratively dissolved, you don't have to do anything with it to make sure it's as current today as it was then from a legal perspective. But the rest is the tax.
Taxation.
Yeah.
How I get paid and all that.
Exactly.
I mean, they pay me under my S corp,
Uh-huh.
Hartwell Properties, and then I pay myself.
Right.
as, you know, I get paychecks and I pay those taxes and all that stuff. So is that what you're talking about?
Yeah, I would run it all through, your accountant. They both have that pass-through tax, so it doesn't, from a very surface level, it should be very similar. But there might have been a reason 20 years ago, maybe because LLCs were kind of new back then.
That's exactly what I was thinking, because that was 30-something years ago, and
Right.
we never even discussed LLCs.
Yep, they were new. I was starting to practice back around that time,
Yeah.
and the LLCs were like, oh, these are brand new, we don't know what it's gonna be. Now, LLCs are all over the place.
Because it does pass through, yes,
Mhm.
the
Mhm.
corporation
Yep.
does not pay taxes. They pay
Correct.
personal taxes.
Yep, and that's
So-
it becomes an S corp through an election to be an S corp, and then you get the pass-through tax. So if it's already set up and working like an LLC, from our perspective, I would say, don't spend the money to change it. If it's working, don't change, don't, how is it?
It's not broken, don't fix
Yeah,
it.
it's not broken, don't fix it.
Yeah.
But it might be a good question for the accountant next time you're doing taxes, just, is there any restructuring here that would get me more tax benefit, which is to all of our benefits, right? So, yeah.
As a county throwing hand off, that's going to real estate agents, going to other businesses.
Oh, yep. So I've seen all kinds of businesses, and that's, my background is not only real estate. Manufacturing company is where I was in-house for many years, so I've seen all kinds of businesses and contracts and, anything. So that's right, we can help you and any of your clients and vendors and anyone else who needs, I think I have a company who just wanted a contract reviewed that delivers the big waste removal bins at houses.
Mm.
So, we do it all. So, all right, well, yeah.
One question regarding contracts. So when people are using their trust to buy and sell real estate, the last transaction that I had, the buyer, both the seller and the buyer were both selling and buying a trust. When the buyer borrowed and got a mortgage, what they did is that the mortgage was in his individual name. What they did is that they kind of redo the agreement, that they would just do a deed, quick claim deed, to just take the property that was bought in his name and put it into his trust. Can you kind of like share how it should be written in the agreement when you're looking at buying and selling in a trust? Because some attorneys ask for the trustee's name to be in the
Right.
signature line.
Yeah, so, and this brings in the lenders and everything else, but if your client knows, it's always easier if your client knows right away, I'm going to buy this in the name of my LLC or my trust. And I'm the trustee, and then we, as the closers, get the trust documents to make sure it's in the name of trustee for the trust, blah, 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 trust. Separate issue from what the lender requires. So, and that's how you do your purchase sale agreement, right? Because then everything's in those names. But then you add a lender in the mix who has their own requirements and what their documentation would be, which would be, it could be totally different. But we will work, the closing attorneys will work with the lenders and the client to make sure it's all how it should be. But you bring up a very good point that I didn't mention with those deed transfers. If you have a person who put it in their individual name, and then they go, oh, I want to transfer this over because I now have this trust that I just created. They need to check with their lender because those due on sale clauses in the mortgage agreements, some of them will trigger a default. So typically, if they call the lender and look at their agreement, because you want to see what triggers the default and how it has to be, maybe, then there are some that exclude out if you are transferring your property from you individually to an LLC that's solely owned by you, it doesn't apply, but some don't. So make sure they check on that before they sign away on a quick claim deed, because if the mortgage companies all of a sudden start looking down for, we want to unload some of these and they find things that have been transferred without permission, it could put them in a bad spot later. So they do need to be mindful of all that and work with their lender when they're signing initially and if they're doing a quitclaim deed after. Or a limited warranty deed or however it's going to be transferred over. All right, well, great. Thank you so much. And I'll be around for a while if you have any specific questions.
Awesome.
Yeah.
Thank you. For those of you in the room, so I know, when we're talking, I was talking with Emma Towers at the office about Amy coming out. So, because we get a lot of questions about partnerships, what they need to say. Everybody is different. There's not a standard. That's why I brought it up, because there's not a standard. It's about what's going to work for you and the partner or partners. And so everyone's like, well, send me an example of one. And we do have a few examples, but that was for that partnership specifically. And so just know that it is about what's going to work for you. And there are some generic like guidelines out there, but overall it's what's going to work for you. Second thing I want to say is for those in the room who do not have wills, from personal experience, I'm gathering some people have had personal experience too. Even if it's a basic will, please have a will, especially if you are married and you have children, especially if you are a blended family through real estate, much less personal experience. It is a nightmare if you don't have one. You can, I mean, close your ears. You can get them online. That are inexpensive. Like if that, if that's a concern, just have something basic somewhere. And correct me if I'm wrong, that if you can file them with a probate office.
And I've had people ask that, I guess you can, but.
Yeah, so I personally did for
Did
my
you file
father,
yours?
because he was in Forsyth County, so I filed it while he was terminally ill with the probate office that way, because we knew, like, we'd already made all the arrangements, that way it was there, so I didn't have to go through that step. Some people do, some people don't, it saved us some time, but I don't know, like, everybody's
I
kind of,
have one comment. If you do your own, pay very close attention to the requirements of how to sign it. Because if it is not signed properly, it's
null and void.
doesn't exist. So that's kind of a pitfall. If you do your own, it's not hard. Just make sure you can't have someone that's a beneficiary witness it. You need to.
Really?
But it is easy to go. I mean, we had gotten someone sent a half a page yesterday. Here's my will. And it's literally a paragraph, not signed, nothing. We're like, it isn't actually enforceable. And she was sure it was. So just pay attention to that.
Yeah,
So.
yeah, important stuff. And it's like the morbid thing you don't want to talk about, but it's super, super important. And it's for the people that are going to be here to take care of all of your things. If something were to happen, we're not promised tomorrow. So just on behalf of those that love you, help them. This is a great, it's an awkward and weird conversation, but it's really important. So anyway,